welcome back, everybody. Episode 133. Yeah, it's only been a couple days. We're pre recording tonight because, well, I'm fleeing the country in a few days. So at least this will allow you guys to listen to me while I'm gone. For at least 1 week, anyways. We'll see if we're going to try and hop back on again before the end of the week, but who knows. So tonight we are going to cover the FLSA and what it really means to us. FLSA, Fair Labor Standards Act. What is that about? Well, that's how we're paid. The how and why and all that good junk. And Meow over here has definitely went down the rabbit hole with it in the past, so I'm just kind of gonna feed in where necessary. Otherwise, I'm gonna say take it away, Meow and Josh.
Alrighty. So the FLSA, or the Fair Labor Standards Act, is what establishes minimum wage, overtime pay, record keeping, child labor standards, and it's affecting full-time and part-time workers in the private sector and in federal, state, and local governments. Now, there's different divisions of the Department of Labor, and the Wage and Hour Division, or WHD, of the United States Department of Labor, DOL, administers and enforces the Fair Labor Standards Act with respect to private employment, state and then local government employment, and then federal employees of the Library of Congress, United States Postal Service, Postal Rate Commission, and the Tennessee Valley Authority. The FLSA is enforced by the U.S. Office of Personnel Management, or OPM, for employees of other executive branch agencies, and by the U.S. Congress for covered employees of the legislative branch, which it's also kind of interesting because we might be in a government shutdown tomorrow, but that's a whole nother side quest story right now. But so special rules apply to state and local government employees and involve fire protection. There's different laws for the fire department, law enforcement, volunteer, and compensatory time off instead of cash overtime pay. And a lot of this information that we're going to go over, it's on the Department of Labor website, and then later on we'll kind of go into it and how it pertains to us a little bit more. But just kind of a basic overview of the Fair Labor Standards Act. So it's covered non-exempt workers are entitled to a minimum wage of $7.25 per hour, and that was effective as of July 24th, 2009. And I know that there's different regulations that affect you by state, but in terms of postal workers and federal workers, we are under the umbrella of our national agreement and our contract. So without the contract, we would be making $7.25 an hour. So wages required by the Fair Labor Standards Act are due on the regular payday for the pay period covered. Deductions for wages for items such as cash or merchandise shortages, employer-required uniforms, or tools of the trade are not legal, where they would reduce an employee's wages below the minimum hourly wage required by the Fair Labor Standards Act, or reduce the amount of overtime pay under the Fair Labor Standards Act. So one of the things that's kind of interesting also is that even though we have the Fair Labor Standards Act, it does not require the employer to give you vacation, holiday, severance, or sick pay, meal or rest periods, holidays off, or vacations, or even premium pay for weekends or holiday worked, and it does not require them to give us pay raises, fringe benefits, or a discharge of notice, reason for discharge, or immediate payment of final wages to terminated employees. There's other laws and stuff along those lines, but the Fair Labor Standards Act does not mandate enforcement or collection procedures for unusual or promised wages or commissions in excess of those required by the Fair Labor Standards Act. But there's going to be other laws and stuff that cover that. So who is covered? It's just the normal employees and workers um, that are just living their life. And where did it go?
Where you left it?
I know. Well, there's some stuff that doesn't pertain to us. We're not tipped workers, so we don't really have any of that. Um, but the Fair Labor Standards Act is also what helps regulate for us to have the 8-hour workday or the 12-hour and the overtime. So there's terms that are used in the Fair Labor Standards Act, such as a work week. A work week is a period of 168 hours during seven consecutive 24-hour periods. It may begin on any day of the week and at any hour of the day established by the employer. For us, it's Saturday to Sunday. Sorry, it's Saturday to Friday. Generally, for purposes of minimum wage and overtime payment, each work week stands alone. There can be no averaging of 2 or more work weeks. Employee coverage compliance with wage payment requirements and the application of most exemptions are determined on a work week basis. And then hours worked, covered employees must be paid for all hours worked in a work week. In general, hours work include all time an employee must be on duty or on the employer's premises or at any other prescribed place of work from the beginning of the first principal activity of the workday to the end of the last principal work activity of the workday. Also included is any additional time the employer is allowed to work. So that's kind of that. And then record keeping. The FLSA requires employers to keep records on wages, hours, and other items as specified in the Department of Labor record keeping regulations. Most of the information is of the kind generally maintained by employers in ordinary business practices and in compliance with other laws and regulations. The records do not have to be kept in any particular form, and time clocks need not be used. So, like our trip sheets, we write that on there. With respect to an employee subject to the minimum wage provisions or both the minimum wage and overtime pay provisions, the following records must be kept. Personal information, employee's name, home address, occupation, gender, and birth date if under 19, hour and day when work week begins, total hours worked each workday, and work week, total daily and weekly straight time earnings, and then regular hourly pay for any week when overtime is worked, and then total overtime pay for the work week, deductions from or additions to wages, and then total wages paid each pay period, date of payment, and pay period covered. Records required for exempt employees differ from those for non-exempt workers. Special information is required for home workers, for employees working. So, and then I'm not going to go over that. So then computing overtime, and Josh will go over some of this in a little bit too. That's going to be more specific for us. But overtime must be paid at a rate of at least 1.5 times the employee's regular rate of pay for each hour worked in a work week in excess of the minimum allowance in a given type of employment. Generally, the regular rate includes all payments made by the employer to or on behalf of the employee, except for certain statutory exclusions. The following examples are based on a 40-hour work week. So you would get the hourly rate, regular pay for an employee paid by the hour. If more than 40 hours are worked, at least 1.5 times the regular rate for each hour over 40 is due. So that's why, we got, and we'll go over this a little bit more in a little bit, but the RCAs, if they're working, or PTFs, leave replacements, if they're working over that 40 hours, then they're getting that overtime rate and it turns to hourly. So, but then it just as a example, just to say, I think most of us understand it, but an employee is paid $8 an hour, works 44 hours in a work week. The employee is entitled to at least 1.5 times $8 or $12 for each hour over 40. Pay for the week would be $320 for the first 40 hours plus 48 for the 4 hours of overtime, a total of $368. So there is that. And then enforcement of it. So the wages and hour division enforcement of the FLSA is carried out by investigators stationed across the country. As WHD authorizes representatives, they conduct investigations and gather data on wages, hours, and other employment conditions in order to determine compliance with the law, regardless of workers' immigration status. Where violations are found, they will recommend changes in employment practices to bring an employer into compliance. But we also have the union, in which kind of, and you can't be retaliated against if there's some issue that's going on with it. Um, but other things too is that there's other acts and other labor laws, um, and there's like a whole list of different ones, but a lot of them don't necessarily pertain to us. But one of the other ones is the Family Medical Leave Act, which entitles eligible employees of covered employers to take up to 12 weeks of unpaid job protective leave each year with maintenance of group health insurance for the birth and care of a child, for the placement of a child for adoption or foster care, um, or a spouse or parent with a serious health condition, or for the employee's serious health condition. So that's another thing that's kind of grouped with this. Trying to think of what else. So the other thing that's kind of important with this is that equal pay, and the equal pay provision of the FLSA prohibits gender-based wage differentials between men and women employed in the same establishment who perform jobs that require equal skill, effort, and responsibility, and which are performed under similar working conditions. These provisions, as well as other statutes prohibiting discrimination in employment, are enforced by the Equal Employment Opportunity Commission, or EEO. So there is also that. But so just to kind of summarize that, so the Fair Labor Standards Act is what gives us, the overtime rate, but our contract is actually what gives us a lot of the benefits. So I'm going to turn it over to you, Josh, and he's going to go over, how it more so pertains to us as rule carriers versus us as just normal employees of the country.
Okay, and I do apologize because this is going to be a bunch of reading, and that's not one of my strongest suits. But we're going to go in the contract, the national agreement, Article 9, which is compensation, salary, and wages, Section 2, compensation, allowances, and fees, Section A, compensation pursuant to the Fair Labor Standards Act, FLSA. 1. FLSA Section 7E2. It is desired by the parties that certain rural letter carriers shall be employed on an annual basis at a guaranteed annual wage, and that such rural carriers shall not be required to actually work more than 2,240 hours, which is the 2240, during the guarantee period of 52 consecutive weeks as specified below, pursuant to Section 7B2 of the Fair Labor Standard Act. As amended, therefore, the parties agree as follows. A. Regular carriers receive evaluated compensation assigned to routes having the number of evaluated hours of required service per week shall be guaranteed an annual wage equal to the corresponding amount for their attained step for 2,080 hours of actual work during the guarantee period of 52 consecutive weeks as set forth in paragraph H, and that's the 2080. B. Consistent of the past pay practice, evaluated carriers assigned to routes having evaluated hours in excess of 40 per week shall receive compensation for such hours in addition to the guaranteed annual wage. However, the employer may at any time reduce or increase such carriers' total compensation by adjusting the number of evaluated hours of their routes downward or upward, but not to a salary level below the guarantee set forth at the beginning of the guarantee period. Therefore, compensation paid to the evaluated rural carriers in excess of the amount of compensation annually guaranteed for 2,080 hours of actual work shall not be considered guaranteed annual wages. C. The employer may at any time increase the total compensation paid evaluated at carriers assigned to routes having evaluated hours of 40 per week or less by adjusting the number of evaluated hours of the route upward. However, compensation paid to such evaluated carriers in excess of the amount of the compensation annual guaranteed for 2080 hours of actual work shall not be considered guaranteed annual wages. D. Regular rural carriers receiving non-evaluated compensation assigned to routes having a number of paid miles shall be guaranteed an annual wage not less than the corresponding amount for their attained step for 2080 hours of actual work actual work during the 52 consecutive week period as set forth in paragraph H below. E. Consistent with past pay practice, non-evaluated carriers assigned to routes having 43 or more paid miles shall receive compensation for such paid miles in addition to their guaranteed annual wage. However, the employer may at any time reduce or increase such carriers' total compensation by adjusting the number of paid miles of the route downward or upward, but not to a salary level below the guarantee set forth at the beginning of the guarantee period. Therefore, compensation paid to non-evaluated carriers in excess of the amount of compensation annual guarantee for 2080 hours of actual work shall not be considered guaranteed annual wages. The employer may at any time F. The employer may at any time increase the total compensation paid to not evaluated carriers assigned to routes having 42 or less paid miles per week by adjusting the number of paid miles of the route upward. However, compensation paid to such non-evaluated carriers in excess of the amount guaranteed for the 2080 hours of actual work shall not be considered guaranteed annual wages. G. The hourly rate for all regular rural carriers compensated pursuant to FLSA Section 7B2 shall be the amount agreed upon. H. For all regular rural carriers compensated pursuant to FLSA Section 7B2, the 52 consecutive week guarantee period shall be consecutive, beginning and ending with pay periods. I. Any regular rural carrier compensated pursuant to FLSA Section 7B2 shall receive overtime compensation as set forth in paragraph K below for hours actually worked in excess of 12 hours in any one workday or in excess of 56 hours in any work week. All hours paid in accordance with Article 9.2.C.5.F3 shall not be included in hours worked over 56 in any work week. J. In the event any regular rural carrier compensated pursuant to FLSA Section 7B2 is required to actually work more than 2080 hours within the 52 consecutive week guarantee period, such carrier shall receive overtime compensation as set forth in paragraph K below for all hours actually worked in excess of 2080 up to 2240 within the guarantee period. All hours paid in accordance with Article 92CF3, 92C5K, and I shall not be included in hours worked in excess of 2080 up to 2240 in the guarantee period. K. Overtime compensation for regular rural carriers compensated pursuant to FLSA Section 7B2 shall be paid at the rate of 150% of the carrier's regular rate. The regular rate for such carriers shall be the total amount of compensation earned for hours actually worked since commencement of the guarantee period, excluding previous overtime pay divided by the total number of hours the carrier has actually worked since commencement of the guarantee period, excluding previous overtime hours. I. For a regular rural carrier compensated under FLSA Section 7B, Christmas overtime compensation, if appropriate, shall be paid in the regular check following the pay period worked. Any Christmas overtime pay hours paid at the FLSA overtime rate shall not be included in hours worked in excess of 2080 up to 2240 in the guarantee period. M. No regular carrier compensated pursuant to FLSA Section 7B2 may actually work in excess of 2240 hours within the 52 consecutive week guarantee period. In the event any such carrier actually works more than 2240 hours within the guarantee period, the agreement under FLSA Section 7B2 will be considered void, and such carrier shall be compensated for all hours actually worked during the guarantee period in accordance with FLSA Section 7A. And hours of absence from duty are not to be counted in determining the number of hours actually worked by a regular rural carrier compensated pursuant to FLSA Section 7B2. O. The employee appointed as a regular rural carrier during the guarantee period as set forth in paragraph H, except on routes of less than 35 evaluated hours, shall be compensated on the evaluated schedule under Section 7B2 of the Fair Labor Standard Act, provided the carrier agrees in writing at the time of appointment to terminate the guarantee agreement on the last day of the pay period as defined in Articles 92A1H. Such an agreement by any rural carrier is irrevocable. Such an employee shall be compensated in accordance with FLSA Section 7B2 beginning the first day of the next 52 consecutive week guarantee period. A carrier who does not agree to terminate the guarantee as described above shall be compensated at the rate in accordance with Article 8.3 in the attained step and overtime for work performed only after 8 hours on duty in any one service day or 40 hours in any one service week, pursuant to Section 7A of the Fair Labor Standard Act until the beginning of the next guarantee period, at which time the carrier shall be compensated under the provisions of Section 7B2 of the Fair Labor Standards Act in accordance with Article 9.2.
So when a rural letter carrier compensated pursuant to FLSA Section 7B2 resigns, retires, is properly discharged, or is properly terminated for other suitable reasons during the guarantee period, this section terminates as to that carrier, and there is no further obligation under this section on the part of the employer, provided the section has been compiled with up to that time. Q. Where a rural carrier compensated pursuant to FLSA Section 7B2 is properly placed in a non-pay status, such carrier shall not be compensated for such time, and the compensation which would otherwise have been paid will be deducted from the employer's guarantee obligation under FLSA Section 7B2. R. A regular rural carrier compensated pursuant to FLSA Section 7B2 who is transferred or reassigned either voluntarily or involuntarily to another position within or without the rural letter carrier bargaining unit during the 52 consecutive week guarantee period shall not receive less compensation for the balance of the guarantee period than the carrier is guaranteed under this section. S. Compensation provided pursuant to temporary deviations or seasonal route adjustments will not at any time be considered part of a rural carrier's salary guarantee. T. When permanent or long-standing route conditions beyond the control of the rural carrier cause or are expected to cause the rural carrier to exceed the evaluated hours of the route and to exceed the hours of the annual guarantee for the route, the employer shall provide suitable relief or shall provide appropriate compensation for the actual hours worked in excess of the annual guarantee. Under such conditions, rural carriers shall not be expected to use leave in addition to that normally required to meet the route evaluation or guarantee requirements specified in the agreement. In the event the provisions of this section conflict with any postal service regulation, manual, or handbook, the provisions of this section will be deemed controlling. And then section 2, FLSA section 7A, the following employees shall be compensated in accordance with FLSA section 7A. Evaluated carriers assigned to routes having less than 35 hours of required service per week. And then B, regular carriers receiving non-evaluated compensation assigned to routes having less than 31 paid miles. C, part-time flexible rural carriers. D, substitute rural carriers. E, rural carrier associates. F, rural carrier relief employees. G, assistant rural carriers. H, employees appointed as regular rural carriers during the guarantee period not covered by Section 7B2 of the Fair Labor Standards Act. In the event the provisions of this section conflict with any Postal Service regulation, manual, or handbook, the provisions of this section shall be deemed controlling. So that is, well, the other part of it too. B? You want me to read section B of it too?
Well, I want to say before we go into that, I just wanted to. I know that was a lot of reading, and some of those sections were talking about the mileage routes, which there's only a couple left in the country.
Mm-hmm.
So that does not affect most carriers. There's only, like I said,
There's
two or
one
three,
one
maybe.
left. One left in the country.
Okay,
Hanging on.
one left in the country. Yep. So anything that was talking about mileage pay only affects that one person.
But
In
they've got to
regards to some
include
of
it still.
yes, in regards to with that with the 20, it was saying basically they were guaranteed the 20/80 hours, which is on your 4241A, where it has your actual salary at your evaluation, and then that guaranteed salary, which is if you drop to 40 hours or below. And with the overtime, it talks about if you go anything over the 40 hours in a week. So if you're on a 43K, you're getting paid 40 hours at your regular hourly rate, and then 3 hours at the overtime rate of 150%, which is already calculated into your base pay.
The other thing to kind of tie it all as a conglomerate together here too is, so in order for us to have our evaluated compensation system that we have, the union and Congress had to kind of, and the Postal Service had to kind of come up with a solution for us to be on that evaluated system. And on the union website, it's under Fair Labor Standards Act, but there is an analysis of all of the Fair Labor Standards Act provisions inside of the NRLCA agreement. And it's a little dated. It's from 1988, but it's still as prevalent now as ever before. And hence why, some of that mileage verbiage is still in there, because there was more of those routes at that time. But us having the HJK routes and the hours and those sorts of things are pertinent, and hence why there's a lot more. It's a little heavy. I mean, the
The gist of it really is we fall under the FLSA even though we're considered salary. We're not an exempt salary classification. That's why we
Yeah,
fall under the FLSA.
yes.
yeah. Uh, the evaluated system is kind of a hybrid salary hourly.
Yeah.
Hourly.
Yep.
But in order for us to stay in compliance with labor law, the NRLCA had to kind of finagle it. Well, I'm not going to say finagle it. They needed to make it fair to us still and allow us that benefit of that evaluated system. That's why I know we're kind of weird with our evaluated system, but I know some people go, why don't we just go hourly? but there's been years and years of us, some people still can beat their evaluation and be paid for 43 hours, So,
On a national average, we are under overall. We are under the evaluated time. And I was just
so
quickly glancing over B, section B,
uh-huh.
and if you wanted to, it's a short one, but it's not directly related to what we were trying to cover tonight.
Yeah, that's fine. We don't need to cover it. It's just I just look at the things that say FLSA and then I go, "Oh, what is it?" But we kind of already covered it. Well, with your work schedule. So, if, there's some of us that you work 6 days if you're an H route, and there's still provisions based upon your relief days and such, but that kind of is there, but not all of it. Um, but I can kind of go over. There's um, a section inside of F21, which F21 is the time and attendance manual, and it's section 540. It's Fair Labor Standards Act. Um, and again, so the following employees are compensated in accordance with FLSA Section 7A. Regular rule carriers assigned to evaluated routes having less than 35 hours of required service per week, or mileage routes having less than 31 paid miles per week. And then B, employers appointed as regular rule carriers to routes covered under 7B2 after the beginning of the guarantee period who do not agree in writing to terminate the guarantee agreement at the end of the guarantee period. At the beginning of the next guarantee period, though, the carrier shall be compensated under provisions of 7B2 of the FLSA. And then substitute rule carriers, designation 72, serving a vacant route or a route where the regular carrier is on extended leave, who do not agree in writing to terminate the guarantee agreement. And then substitute rule carriers, designation 73, relief rule carriers, designation 75, rule carrier associates, designation 74 and 78, PTFs, designation 76, auxiliary rule carriers, designation 77, and rule carrier associates assigned to an auxiliary route, designation 79, and temporary replacement carriers, designation 70, and then regular rule carrier compensated pursuant to FLSA Section 7B2 who actually work more than 2240 hours within the guarantee period. But there's going to be different rule carriers that have where is it? So I know we went over the 4241A and M. There is actually a thing on the bottom of your 4241A that says your FLSA code.
Mm-hmm.
And most of us, I think, are, what is it? Is
Mine
it
says
B?
B.
yeah,
No,
B. Yeah, mine says
B.
B.
But there's going to be a couple of them that there's FLSA B, which are like the ones that are on the evaluated system. But there's also FLSA A, which are the ones having more than 35 standard hours per week who do not agree to terminate the guarantee, who do not agree in writing to terminate the guarantee at the end of the guarantee period. And they're the ones that are converted automatically to be at the end. Like when you first go regular, you want to be hourly essentially. And then there's also, it's a rarity, but I've seen it happen. It's FLSA Code N. And FLSA Code N applies to regular rule carriers, designation 71s only, assigned to routes having less than 35 standard hours per week, or RCS having less than 31 paid miles per week. And the situation where I saw that happened was that the route was below 35 standard hours for 2 years. And that it converted it and it was a nightmare. And I think there's not that many of them, but I don't know if it changed now with the new evaluations.
Yeah, that's where your
Um,
accessing stuff comes into play.
yeah, well, um, if the route goes vacant, then they can actually convert the route back to an aux route.
Mm-hmm.
But if it's not vacant, then it's real messy. and that's a whole other. But you're under FLSA code N, and it'll say it on that bottom of that 4241A. So if you're listening to this, don't get surprised with that. But and then what else? I'm
What
trying to
was
think of what
the
else.
FLSA code P?
FLSA code P is, hold on, let me pull it back up. BANL. P applies to auxiliary role carriers, designation 77, part-time flexible role carriers, designation 76, substitute role carriers, designation 73, RCRs, designation 75, role carrier associates 74, 78, and 79, and then temporary replacement carriers. So, like if you're a sub that's been holding down an aux route, then it would be that under that code, I think. So, but and
Are
then
there
we
any
all know,
TRCs left?
I think there's a couple.
Because I know they got rid of that position, and that was the same like the CCAs where they had to have a break in service.
Oh, the TRC?
Yeah.
Yeah, temporary relief carriers.
Yep. Yeah, that one's gone to the wayside. Last I
I
knew,
think there's still maybe two.
I don't know. I think that's RCRs.
Oh, that they have, yeah.
Yeah. Now, TRCs,
But
they all
they're
had to
still in,
convert to RCAs.
yeah.
Yeah.
Yeah. So, but what else is I gonna? So the other thing too that I know somebody has asked about, because I think we pretty much covered that, but there's a newer thing that's kind of with the Fair Labor Standards Act that coincides that I know somebody asked about. They, and part of the big beautiful bill act that they signed, there was
Oh,
like
the
no tax
overtime.
on, yeah, and it says like there's no tax on tips, which doesn't affect us, but there's no tax on overtime. And so the language for the bill says effective for 2025 through 2028, individuals who receive qualified overtime compensation may deduct that pay that exceeds their regular rate of pay, such as the half portion of time and a half compensation that is required by the Fair Labor Standards Act and that is reported on a Form W-2, Form 1099, or other specified statement furnished to the individual. Maximum annual deduction is $12,500 or $25,000 for joint filers. Deduction phases out for taxpayers with modified adjusted gross income over 150,000 or 300,000 for joint filers. Taxpayer eligibility deduction is available for both itemizing and non-itemizing taxpayers. And then taxpayers must include their social security number on the return and file jointly if married to claim the deduction. And then reporting, employers and other payers are required to file information returns with the IRS or SSA and furnish statements to taxpayers showing the total amount of qualified overtime compensation paid during the year. And then guidance, the IRS will provide transition relief for tax year 2025 for taxpayers claiming the deduction and for employers and other payers subject to the new reporting requirements. So I'm going to preface this by saying I am not an attorney. I'm not a tax expert. I'm just somebody here. But I'm under the assumption that because it says, what did it say? It said
Qualifying?
qualifying. It's going to mean your actual time, especially for regulars. That
So
it's going
that
to be
would
the
be,
actual.
so that more than likely, I mean, we won't know until tax time when we actually get our W-2s and whatnot. So
Yeah.
and again, I'm just a roll carrier. I mean, I used to love tax stuff. I wanted to do accounting and whatnot back in my teenage years. Don't ask me why, but the numbers thing. The way
Yeah.
that I make and I'm using that word, the assumption is
Mhm.
that it would be for us regular carriers would be that overtime pay for assisting on other routes over the MOU, the
Yes.
overtime pay for work if you claim a DACA 5 if you can,
Yeah. And Christmas
And
overtime.
Christmas overtime.
and Christmas overtime.
I was just going to say, because the beginning of that said not to include your regular pay. Yes,
And our regular pay includes,
already has
yes, our salary
overtime
does.
rate
Again,
for the salary.
that's just a regular rural carrier here making an assumption. Again, we won't know until tax time when we get our W-2s. So,
Yeah. And then for subs, yeah, subs are going to be a lot easier because it's
yes.
just them going over 40.
Mm-hmm.
But for the
Yep.
regulars, typically what'll happen is management's going to, well, it'll be the hours that are going towards 2240
Yes.
versus 2080.
Yes.
But subs over 40.
Again.
So, but we'll see once we get closer to it. And I'm assuming to, I mean, I'm pretty sure the union will put something out with it too.
Mm-hmm.
And it would be nice right now, like if because of the fact of like it's gonna be easier for the subs to figure it out. But for regulars, because of that guarantee year, management's always tracking like starting Saturday until Friday this week. Well, sorry, last year, that what is it, the third or sorry, the fifth? I don't whatever. I keep mixing that up. October
Yeah, October.
October
Hold on, give me a second. I'll go back and look.
October 5th of
5th.
last year.
Yeah. Yes. So
Through October
they're tracking
3rd of
it from
this year.
there. So if you wanted to see, like, if you wanted to look at it for yourself, you would have to subtract out the hours from October 5th of 2024 to December 31st of 2024 and then calculate out, they might have it. They usually have like a list of the 2240 hours,
All
but
right.
subs it'll be easier.
Yeah, that's a whole lot of
But
legal ease that a lot of people won't understand. But like I said, in layman's terms, we fall under FLSA, even though we're technically salary as regular carriers. It puts us under that FLSA, and so we are not the exempt salary that people that would be exempt from being under FLSA. So
Yes.
yeah.
And I've also had a lot of people over the years that have been like, in different states have different rules for breaks.
Mm-hmm.
And because we're federal workers, like me finding out that the Fair Labor Standards Act is not what gives you breaks. It's usually like localized to states, but we have it in our contract. That's just crazy. That was crazy to me. It's like, why can't we amend that so that like if you work 2 hours, you get a 10-minute break, or if you work 4 hours, you get a 10-minute break, and then 5 hours, you get a 10-minute break and a 30-minute lunch, or 8 hours, you get 30 minutes and then two tens, or 15, it
right,
just depends on the state. But here we
right.
don't have that.
And I think it's after 5 hours they're required to offer, and then depending on the like I work for a company, it was after 5 you were eligible for a 30-minute lunch. After 6 you were required to take it.
Nice. Well, to kind of bookend this too, if you want to look up anything that we were saying, Josh was reading, what was it, Article 9.2,
Nine.
right? 9.2. And then
Yes.
you can also go onto the union website and go under if you go into the Steward Reference Guide and you look up Fair Labor Standards Act, there's a document in there that's called the Analysis of the FLSA Provisions of the NRLCA Agreement, and it breaks down what Josh was reading even more so. um and draws it out, and there's even like a Q&A at the back of it. And like I said, it's a little dated, but it's still prevalent now more than ever. And then the stuff I read at the beginning is on the and the other stuff, irs.gov has the no tax on overtime information, and then the Department of Labor has the whole documentation of the Fair Labor Standards Act if you really want to invigorate yourself like I do with the Fair Labor Standards Act. So, but I think that's it.
All right. Does that mean
I
you
know
guys
you're on it.
are ready to wrap this up tonight?
I think so. So
Yep.
now that we're all asleep, though, we're
Yeah. No, we wanted to get that out. This was initially what we were going
yes.
to talk about for this week. So we went
Uh-huh.
ahead and hopped on an extra day and got it talked about for next week. And so this will come out regularly scheduled. And I have a toddler who wants to play with everything, who needs to go to bed. So we're gonna, I'm not gonna, final words for anybody. We're just gonna go ahead and sign off a little bit shorter,
Right
but
out into the sunset.
yeah, don't let it brain meld you, because then you'll know how we feel when we leave National Convention. Um,
Yes.
but on that note,
It,
guys,
un-
stay
unless
safe.
you're one of the,
Go ahead.
I would say, unless you're one of those weirdos like Meow who loves this kind of thing.
Oh, I
Oh
do
yeah.
too. Don't get me wrong. I do. It's
But
playtime
sometimes.
cry, and I have a diaper that just leaked on my lap. So,
Yeah.
All right.
Yeah, you're all good.
Good
all
night.
right, guys, y'all
Good
take
night,
it
Enjoy
safe
your.
everybody.
out there. I will enjoy Italy, and post
Literally.
pictures, and well, we'll talk to you guys next time.
Bye,
All right.
guys.
You have a good one.